First, I can't say what a huge pleasure it is to be invited here. It's a great honor, and I am delighted to be here. What I want to talk about this afternoon to you is the Japanese compulsory license system in the context of orphan works. Orphan works are works whose copyright owner cannot be identified or traced. No one can obtain a license from a right holder, thus using such works is restricted. Also, when an orphan work is used lawfully, its rights are limited or restricted in certain ways. This is why I am speaking about this issue today. To date, no multilateral international treaties on copyright and related rights have had any specific provisions for orphan works. Therefore, no countries are obliged to have a special system to facilitate the exploitation of orphan works. On the other hand, international treaties provide general provisions or case-specific provisions of limitations and exceptions regarding copyright. These restrictions on copyright may appear in certain forms, such as compulsory or statutory licenses, or in permitted uses. Many countries have some type of system for orphan works. The nature of exclusive rights to orphan works may be limited in these systems. Each country can establish its own system, but the system must be within the limits of some principles on copyright, such as the non-formality rule and a three-step test. Japan has adopted a compulsory license system for orphan materials. I will introduce an overview of this system and talk about its past record. The existing compulsory license system was amended following the 2009 recommendations of the Subcommittee on Protection and Exploitation of Previous Works, etc., which was established in January 2007. These issues are mutually related. For example, a term extension may provide more orphan works because of avoiding works from being in public domain. Establishing a system for right holders' declaration of intention would resolve problems related to orphan works to some extent. In the subcommittee's discussion regarding continuing efforts of private sector groups to identify information of right holders, the consensus was that some systematic measures which supplement such efforts should be prepared as a last resort safety net. Accordingly, it was proposed that a more accessible system be prepared. That is, the compulsory license system for orphan works is merely a safety net, and not the usual avenue for normal exploitation of such works. Consequently, compulsory licenses should be used as a last resort. Article 67 in Japan's license system provides a compulsory license for copyright with an unknown owner. New provisions were introduced in 2009. Article 67 bis provides for exploitation of orphan works while an application for a license is pending. Article 103 provides that Articles 67 and 67 bis also apply to neighboring rights. There is another amendment relating to reproduction by the National Diet Library. In this amendment, I will illustrate later. I will provide an overview of this system. Under the existing Japanese Copyright Act, Article 67 permits potential orphan works users to apply for a compulsory license issued by the Commissioner of the Agency for Cultural Affairs. To obtain a license, the user must deposit compensation equal to the ordinary rate of royalty for use of the work, as set by the Commissioner, and prove that a due diligence search for the copyright owner was conducted and that no such owner was found. Copies of works made under a compulsory license must indicate that they have been licensed under these articles. In certain circumstances, applicants may use the orphan works in question while an application for a license is pending before the Commissioner of the Agency for Cultural Affairs if the applicant has already made a deposit of a security amount fixed by the Commissioner. The Commissioner, however, may not issue a license for the use of an orphan work if it is evident that the author intends to discontinue any exploitation of his or her work. Additionally, the Commissioner must also give notice of the issuance of any licenses for the use of orphan works in the official gazette. The concept of diligent search may be most important for compulsory license system. To make efforts to obtain contact information of the right holder includes all the following steps: access to rosters and almanacs etc., which describes names and addresses of the right holder. Search for information by web search service. Inquiry for Mo's etc. Inquiry to the person who conducting business of the same kinds of copyrighted works which you try to use. Inquiry to authors, organizations etc. in the areas of the work which you try to use. Request to the general public information about the right holder. All these steps must be taken for diligent search. According to the manual published by the Agency for Cultural Affairs, it would 1 or 2 months are required before application. How long does it take to get a compulsory license? According to the manual, it takes about 3 months from application to notify the applicant of the result. Fee and cost. Charge for application cost 13,000 Japanese yen per one application. Not every one title. However, all titles must be within the same scope of certain project. If you application to use while an application, additional security money should be paid. Compensation fee is calculated on the basis of ordinary rate of royalty. For example, if you make reprint book of an orphan academic book, and publish 3,000 copies and its fixed price is 800 Japanese yen per one unit. If the ordinary royalty is 7% in the field of publishing academic books, it will cost 168,000 Japanese yen. It is just an example, but the example provided in the government manual. Of course, before application, you have to do diligent search, and it costs a lot. This is an example cost of advertisement of request to the general public information about the right holder, which you must go through. It costs at least 13,860 Japanese yen to advertise of request on the CRIC website. CRIC, Copyright Research and Information Center, is public service corporation authorized by the government and has been developing its activities and programs on authors' right and neighboring rights. With regard to usage of non-Japanese material, the compulsory license system does not distinguish foreign works from the subject matter of the license. This is clearly indicated by the government manual. Therefore, it is possible to be issued a compulsory license for works of a foreign author, as long as the work will be exploited within Japan. The manual indicates that the degree of diligent search for foreign works is equivalent to that of domestic works. I found some precedent that compulsory licenses have been issued to foreign works, but those are somewhat peculiar cases related to English admission examinations. I will illustrate these precedents. I have checked past records of compulsory licenses. Although this database lacks detail, I found that some foreign materials were on the list. I suppose these are very peculiar cases of admission exams. In Japan, some universities have used English materials as a part of their admission examination subjects. In those cases, universities can exploit the material without permission from the copyright holder, Section 36. 1, and without an indication of source, Section 48, 3. Although some publishers want to publish past exams, they have trouble obtaining permission from copyright holders because they cannot know both the copyright holders and the authors of the material on the English tests. Of course, the publishers can ask the universities about the indication of source, but the universities are not obliged to respond to the inquiry. Under such circumstances, the compulsory license system may be the only way to publish past tests for such publishers. I have to talk about the National Diet Libraries, NDL, archive project launched on its website. The digital library from Meiji era includes books whose copyright expired. How does the NDL collect the data for the archive? Under the Japanese Copyright Act, Article 31(2), provides that the NDL can create an electromagnetic record of its library materials for the purpose of avoiding the destruction, damage, or staining of such original from public use. Therefore, for use in the library, the NDL can create an archive without seeking permission. On the other hand, when the NDL make its library materials public on the internet, it must seek copyright clearance, except for materials that are not subject to copyright or those that have been in the public domain. There are two cases in which the NDL must apply for a compulsory license. 1. When both copyright duration equals death year and contact information are unknown, and 2. When copyright duration equals death year is known, but contact information is unknown. Figuratively speaking, Article 31(2) permit the NDL to make inside building archive without permission. So, the NDL is treated like as orphaned home. On the other hand, if orphan home let these orphan materials go outside the inside the home, they need some licenses. Please take a look at this slide. As I mentioned in the other slides, Articles 67 and 67 bis provide for exploitation of orphan works under a compulsory license. If copies of the work are reproduced under a compulsory license, they must be marked as reproduced under a compulsory license, and the date of issue of the license must be indicated. 67. This book is titled Nichiedame, which means the Anglo-Japanese Alliance, and was published in 1902. This is book of joint authorship. The sentence in blue says, this book is released to the public under a compulsory license by the director of the cultural agency. Other information such as the name of author, state of copyright, and the date of issue of the license is included in this page as well. The state of copyright indicates a compulsory license issued by the director of the cultural agency. Indeed, the main user of the compulsory license must be the National Diet Library of Japan. However, the library has not applied for compulsory licenses for foreign authors' materials. NDL is a copyright deposit library. Its system directs to books published in Japan other than published in other countries. It is reasonable to assume that the digital library from the Meiji era is a project as a deposit library. In my opinion, the NDL should not apply for foreign books in order to avoid overlapping investment amongst the national libraries throughout the world. I have seen this concept in the preamble of Proposal for a Directive of the European Parliament and of the Council on certain permitted uses of orphan works. It states, moreover, in order to avoid duplication of costly digitization, member states should ensure that use of orphan works by the organizations referred to in this directive is recorded in a publicly accessible database. Now, we will see the statistics of the compulsory license system, which are open to the public on the website of the Agency for Cultural Affairs. To be honest, the open information is contained in a report that is lacking in detail. However, I will give an overview of the information. First, please take a look at this graph, which shows the number of compulsory licenses granted between 1972 and 1998. Overall, the number of compulsory licenses is quite small. In 1972 and 1977, the number was relatively larger than in other years. In many other years, the number was 0. On the other hand, in the period between 1999 and 2010, the number of compulsory licenses increased gradually. In the past 4 years, the number has dramatically increased. I would like to explain what is going on in the current term. Next, I will show the different categories of licensees in each term. This graph shows the categories of licensees under the compulsory license system between 1972 and 2010. In this graph, NDL means the National Diet Library, and E refers to academic examinations, or licenses obtained for using past tests of English materials in admission examinations in the orphan status. As you can see, the National Diet Library is one of the main licensees as a single entity. Although the statistics do not indicate names of individual licensees, e-licensees seem to be the major applicants for compulsory licenses. The pie charts compare the licenses issued to non-NDL and non-AE licensees across two time periods, from 1972 to 1998 and from 1999 to 2010. The number of NDL and AE licenses rose dramatically after 1998. During the period of 1972 to 1998, no compulsory licenses were issued for NDL or AE-related matters. This situation changed radically during 1999 to 2010. 39% of compulsory licenses were issued for AE matters and 13% were issued for NDL matters. On the other hand, compulsory licenses unrelated to NDL and AE matters also increased during the period of 1999 to 2010. This bar graph shows the number of three different licensee types during 1999 to 2010. NDL licenses account for very few of the licenses. The number of e-licensees increases significantly between 2007 and 2010. Meanwhile, the number of non-NDL and non-E licensees also increases steadily. In conclusion, the rising trend of the number of licenses does not apply only to NDL and D licensees but also to other categories of works. However, the number may still remain very small compared to the number of potential orphan works. The pie chart shows the number of titles subject to compulsory licenses between 1972 and 2010. The NDL is clearly the primary user of compulsory licenses. The Japanese compulsory license system ranges in function. It is a neutral system in relation to its purpose. However, this suggests that, at least on basis of titles, the main function of the compulsory license system is the facilitation of archives. Of course, only 82 licenses in total have been granted since 1970 under the Japanese law. This pie chart shows the type of works subject to licensing in the period between 1972 and 2010. Literary works are the most common types of works for licensing. They account for about 60% of the works. Artistic and music works account for about 15%. Other types of works were subject to licensing, however, none of the volumes exceeded 5%. Copyright law in Japan indicates a compulsory license system for works in cases where the copyright owner thereof is unknown, Articles 67 and 67 bis. The system also applies to neighboring rights, Article 103. Currently, only one such case has been recorded. The performance as instruments included harmonica, piano, drums, flutes, and stringed instruments and is very difficult to identify. The type of use is a CD recording with the intention of selling. To sum up, the purpose of the Japanese compulsory license system is neutral. However, on the basis of the title number, this system is mainly used for archiving. After the amendments of the Japanese Copyright Act in 2009, the number of compulsory licenses seems to be dramatically increasing, but is expected to remain relatively small.